Welcome back, everyone, to the Colorado Oil and Gas Conservation Commission Rulemaking Day 13 afternoon session. We finished up this morning with the party presentations on the 200 series, and we heard closing from staff as well as the La Plata County folks. No one else had time for closing. And so now we are into the commissioner deliberation stage of this part of rulemaking. Normally what we have done is to, at high level, sort of do issue identification. Director Murphy creates a PowerPoint and we identify issues, thoughts, suggestions on the series. I propose we take the normal path and maybe do that again as well. Director Murphy, did you want to initiate anything on this? Oh, the bucket slide.
Notice it's wildly unpopulated.
Very good. Well, I mean, I can start. I only have a couple of areas in which I'd like some attention paid. The 201C piece that we heard a lot of testimony around, and rather than just identify that as an issue, I'll just flat out say I think we should just delete the third sentence on 201C. I think that I appreciate your perspective, Director Murphy, that you know, our interrelationship between ourselves and local governments is defined via our act and local governments acts, and I don't know that that sentence is needed. It has created a lot of consternation, and I don't think that that undoes anything. Our relationship still exists via statute. My second piece is I'd like to hear a little bit from our Assistant Attorney General Kyle Davenport about the whole consternation around standardless standard. And then thirdly, around 218, and just some perspective from maybe staff, what you're thinking about that. Back on standardless standard, I would encourage Assistant Attorney General Davenport and staff to also take a look at the Jim Martin slide that we heard on the second round of Jim Martin testimony when he was able to re-engage. Those are my initial thoughts around the 200 series. I know there's more out there, and so I look to my fellow commissioners for issue identification, thoughts about issues, etc. Commissioner Nanjapa.
Thank you, Mr. Chair. I think those generally capture the items that I had. There was one other piece in 218B. There was some suggested language. Let me see, who was that from? From the affiliated local governments regarding just additional clarity on the contractors and subcontractors in the first part of the sentence, and also the responsibility of the operator. So would like to at least discuss that. And then let's see, there was one other piece. Let's see. Oh, in the standardless standard, there was also an additional slide from Ms. Merlin that, you know, included Mr. Martin's slide and had some additional commentary, and, you know, there was kind of some agreement about the standardless standard, or the need for more detail, but the specifics thereof were perhaps different. So, and then last but not least, I think this sort of falls within the larger 218 bucket, but the idea that while we have a whole separate section on financial assurances, maybe some sort of whether we need to have something in the attestations regarding financial responsibility in the event of whatever. So I think that falls in 218. Actually, I may not be in the right section. I think that's it for now. Thank you.
Thank you, Commissioner Najapa. Commissioner McGowan.
Thank you, Mr. Chair. Thank you. I have all these too, and I want to make sure as we're talking about 218, I think Adams County was interested in getting notice of the transfer before the completion or the approval of Form 9. I just want to make sure we had that included.
Commissioner Gonzalez.
Thank you, Mr. Chair. I think it was TEP Rocky Mountain who brought up the confidentiality concern in 208B and the ability or inability to appeal the director's decision there. Otherwise, the list is consistent with what I've got.
Yeah, that was TEP and Mr. Jewell that brought that up, and I appreciate you flagging that. Commissioner Messner, did you have others to add?
I couldn't find my cursor. I apologize for that. Yeah, there was just one other thing, and I'm just going to put it on there. This is not something I'm pushing, but there was the wish to consider a definition for protect. And I don't think we've had an opportunity to talk about that or to hear from staff or the Attorney General's office regarding the benefit or lack of benefit of that.
I think that was raised by the La Plata County folks at a minimum. I think that also raised whether there's a need for further defining the minimize and mitigate. And so just, heard that as well. I don't know that I think that's necessary, but, to make the list full.
Mr. Chair.
Commissioner Putnam, yes.
Thank you, Mr. Chair. In addition to the items already listed under 218, I think it may have been the 350 group and Ms. Merlin who mentioned the possibility of having joint and several liability for instances where assets may have been transferred into a new entity that is no longer viable and whether there's any ability to reach back. In part, I think that's a question for council in terms of whether that's something within the scope of the commission's authority. But I think, especially in the current environment, is a question worth raising. Probably tie that with the financial ability. This is backwards looking, that one's forwards looking.
Thank you for that, Commissioner Putnam.
Mr. Chair.
Oh, sorry. Yes, I'm in the for what it's worth category. I'm also trying to eat lunch because I lost my lunch hour. So I apologize if I'm being less responsive than normal. Commissioner Najapa.
No worries, Mr. Chair. There was also the issue, I just wanted to maybe hear from staff about the issue that La Plata and San Miguel raised with respect to the transfer of non-Indian interests to the Southern Indian tribe, and what happens then in terms of how or where our jurisdiction applies in that sort of instance. So I wanted to just better understand that. I think they're requesting, as they noted in their verbal remarks and also in their pre-hearing statement about it running with the land. But I just wanted to maybe get AAG Minor or AAG Davenport's thoughts on that.
I'm not seeing commissioners further raise hands or unmute. Maybe we have defined the universe of the 200 deliberation, which I think is a testament to the good work that staff did in that the universe is not large. Commissioner Najapa.
Sorry, Mr. Chair. There's just one other thing, and this is again more of a question for staff. And I apologize because I was looking at several of these notes as you were going through some of the staff closing, Director Murphy, but I wanted to better understand the issue around where we may be able to have additional authority or just how these rules would apply to existing facilities. And I think in particular, La Plata County, actually, I think it was San Miguel, Ms. Paget had mentioned as it relates to kind of like the seasonal timing limitations, for example, for wildlife and that sort of thing with respect to timing of operations and or timing of activities on existing sites.
Chair, if I may, I don't know if AAG Minor has noticed that I went ahead and threw him under the bus on that question.
AAG Minor.
Yes, thank you. Would you like it addressed now or in the course of the
Uh,
deliberations?
We can go through it in the course of, I think. So we think this is the list, team? All right. I kind of want to start on the protect question, in that, to me, protect is difficult to define because the entire suite of rules addresses protect. And so, I mean, it's hard for me to want to distill that down with more precision, given the breadth and depth and scope of the rules themselves. That's a pretty high level answer to the question. But I think of course, if the commissioners think that it's appropriate to explore a definition, we'll take a hard look at it. And then on the minimize and mitigate, that's a piece that came up in, I believe, the 300 series conversation earlier, and dovetails with some of the conversation or some of the rules that have been noticed and definitions that have been noticed in as they relate to wildlife in the 800, 900, 1200 rulemaking. And so I think we agreed to kind of recognize that that conversation would be folded into the upcoming hearings on those. And so that's my understanding of kind of where the placeholder or where that issue is right now. But the question of whether to define protect is a little bit new.
Thoughts on that point by commissioners? I think silence is assent, perhaps.
Only in this context. With that, do we want to turn to 201? And I can actually like build out a specific slide on it.
Yep.
Okay.
And perhaps we could turn to Assistant Attorney General Davenport or AAG Minor for the first question. This is the question around the current rule says operators will comply and they will ensure their contractors apply versus Ms. Burke's suggestion that we should reorient that in a different fashion. I don't have exactly what her language was, but.
Thank you. If I may, Mr. Chair.
Yes, please.
So staff certainly reviewed the LGC's suggested language as well as Gunnison County's suggested language. I believe Ms. Burke's slide included both. The reason staff has not adopted that suggestion is that staff feels that the intent behind that language is encapsulated within the language of the rule, right? That when contractors and subcontractors are conducting operations at an oil and gas location, there has to be compliance with the commission's rules. the reason that we did not adopt their language is that it would in practice essentially create a regulatory responsibility that would sort of mean the commission takes enforcement action or directly regulates the subcontractors and subcontractors themselves. And there isn't a requirement, for example, that every single subcontractor who comes to a location file a Form 1, like a registration as an operator. In practice, staff doesn't always know who every contractor is and who every subcontractor is. But for the purposes of enforcing our rules, there is absolutely an entity that is responsible for compliance, and that is the operator. And that's why the wording was chosen as it was, which doesn't mean that staff can't work on changing the wording if that is your direction, but that is sort of why staff did not adopt the suggestion from ALGC and Gunnison County in the course of reviewing the parties' pre-hearing statements.
Thank you for that explanation, AAG Minor. Do commissioners have thoughts having heard that? I am somewhat of the perspective that if it's good enough for Joel, and I appreciate his drafting ability, so I would be comfortable in leaving it as is, despite the fact that I have high regard for Ms. Burke. Okay, there's our direction there. 201C, the suggestion from many parties was the third sentence was problematic. I don't know, as I mentioned, I don't know that I agree with those parties relative to what the third sentence says or does, but I am in agreement with staff that deleting it does not alter the statutory relationship between our entity and local governments. That's defined by statute, and I don't know that it's necessary. And if it would remove angst amongst parties, I'm okay with that. Commissioner Gonzalez, did you?
I was just going to throw my concurrence on that, Mr. Chair.
I see a subtle nod up and down from Commissioner Najapa. A more firm such as consent from McGowan. Commissioner Messner, did you want to weigh in? You're good? Okay. The third sentence is deleted. We'll let the effortless Ms. Murphy catch up.
Mr. Chair, if I may make a brief remark while Director Murphy catches up.
Yep, please do.
I just wanted to return to the avoid, minimize, mitigate definition question and remind the Commission that, and Mr. Davenport can add more here as well, that based on the vote that you took this morning, recognizing that sort of the 200 through 600 rulemaking is ongoing and that there may be additional reasons for you to look at the record for that rulemaking in the course of your 1200 series deliberations, you certainly can review parties' filings with respect to the definition of avoid, minimize, and mitigate that they made in the 200 through 600 series rulemaking in the course of considering staff's proposed edits to the 1200 series. And any additional motions or things related to the record that need to be done can be done later. I just want to make sure you know that you don't need to disregard parties' filings on that topic in the course of considering the 1200 series rules, even if those filings were made in the 200 through 600 series rulemaking.
Thank you. That's helpful advice and guidance, AG Minor.
Chair, if I may jump into the second bullet on this, the standard. I would start by saying staff has not put forward rules that it thinks are standardless, right? We have excellent counsel. We are trying to be extremely thoughtful about what we do. I also recognize that there's always also room perhaps for improvement. And so, we could take the feedback from Mr. Martin and Ms. Merlin and take a look at it if that would be the appropriate course of action and come back to you with what we think may be some important refinements or not after we kind of noodle on it again. unless there's really clear or specific direction from the commissioners on this point in particular.
I think I'm comfortable with that, Director Murphy. We heard from, I think it was AAG Minor in opening on either the 200 series or one of the others, I can't remember, the comments from our attorneys that as drafted, or maybe it was from AAG Davenport, I can't remember, that as drafted, this complies with the APA and the standards are, there. But I also don't have a problem in staff further looking at the information we've received from our colleagues, Mr. Martin and Ms. Merlin, and seeing if it can get better. What are other commissioners' thoughts about this issue? Commissioner Najapa and then Commissioner Gonzalez.
Thank you, Mr. Chair. I was just going to note, I think that, you had posed a question about whether it was too general or whether that sort of language was okay, but, having some parameters or some guardrails. And I believe that there were some examples of other places in the rule where there was a little bit more specificity. I believe that was where Mr. Martin was going. I don't have great notes with respect to what Ms. Merlin had said, but had a note to go back and look at her slides. So I think I would definitely defer to the staff on that. But I think it was, just a little bit similar of creating a bit more specificity if possible.
Commissioner Gonzalez, I think you were next.
Yeah, thank you, Mr. Chair. I don't have too much to add here. I can appreciate the concern around the lack of definite standards associated with our mission and with our statutory directive. But when I read them all in whole, I think the amalgamation of all the rules really defines that and really kind of makes it clear what we're trying to accomplish with the protection, the mitigation, adverse impacts, and what we mean by all that. That being said, I think that we're trying to get the best rules here, and I would appreciate Director Murphy taking another look and making sure that that's where we're at.
Commissioner Messner.
Well, thank you, Mr. Chair. And I think that as I had indicated before, it makes people very uncomfortable to not have very specific and prescriptive regulatory process. And I understand why that is, but I think in the reality, when we look at a performance-based regulatory scheme and we look at the rules that have been developed, which I think have very clear standards, it does allow discretion, it does allow for creativity, it does allow for different technologies and different approaches, and it's not saying that it's a one-size-fits-all, but rather says this is what you need to accomplish. We need to minimize adverse impacts. We need to protect for public health, safety, welfare, the environment, and wildlife resources. And there's all kinds of different prescriptive pieces within the different layers and series of the rules, but the overarching principle stands that in a reasonable manner, we need to protect public health, safety, welfare, the environment, and wildlife resources and minimize adverse impacts. And so while I appreciate, on both sides that they're wanting to see things more black and white, I actually think you get a better product, and I have experienced that utilizing performance-based land use process within Gunnison County, that you end up getting a better product and something that is better for applicants, better for folks that potentially could be impacted, better for the environment, better for wildlife, when you create a little discretion in the approach on how you're going to meet the mission. And so I appreciate and think that there's clear standards I appreciate our approach. I appreciate the work that staff has done on this, and so, yeah, those are my thoughts. Thank you.
Mr. Chair.
Commissioner Putnam.
Thank you, Mr. Chair. And just, I think following up with similar thoughts to Commissioner Messner, I do think that there's adequate guidance here, and I'll use an analogy from CDPHE's programs under our water quality programs and under the Water Act and our water regulations. We have both very prescriptive standards for precisely how much of various pollutants need to be in the water that we refer to as quantitative standards. But we also have an overarching qualitative or narrative guidance that says, and you can't put anything in the waters that will impair health, environmental quality, et cetera. That's a paraphrase. And that's enforceable. We've had that for a long time. It generally works. We aim to create those quantitative standards, which take time. And because we can't anticipate everything in the world that will happen and some of the unique circumstances or creativity or other examples that Commissioner Messner had, we have that narrative standard to fall back on, but also provide guidance under that standard from a kind of staff level, sometimes approved by our Water Quality Control Commission, to provide guidance. This is long-standing. It's not unusual to have something, I think, similar to the approach that's being proposed in your regulations, and I think it's workable. That being said, I think the kind of arc of things is to move things into as much specificity as possible, to provide as much guidance, to provide as much certainty as possible, and we should aim for that where possible. But I think it would be a mistake to pull out the kind of catch-all to make sure that the sum and substance of all that thing adds up to the protection that's required under Senate Bill 181.
Thank you, Commissioner Putnam, for those thoughts. Other commissioners with thoughts on this issue? Director Murphy, do you feel you've received a fair amount of direction on this? Seeing a nod of an up and down fashion is yes.
Yes, I do, Chair. And if we want to jump into the 208B piece, I would ask AAG Minor to jump in and talk through where we are today and then receive direction.
Thank you, Director Murphy. And if I may, Mr. Chair.
Before we go there, I just would like to finish up on the standardless standard and just open question to AAG Davenport, our lawyer, if he had thoughts about that. You don't have to have thoughts, Mr. Davenport, but if you did, before we close that out, I would like to hear from you.
Thank you, Mr. Chair. Excuse me, I don't have new thoughts in the sense that I think they've already been ably said by Mr. Minor and I think expressed by Commissioners Putnam and Messner as well. I think the overarching point here is that the Commission always has an obligation to ensure compliance with the Oil and Gas Conservation Act. And that's all I have to say.
Great, thank you. Okay, now moving to confidentiality appeal, AAG Minor, our other Attorney General with us.
Thank you, Mr. Chair. So you'll have to bear with me here as we get through some sort of details and nuances of the 200 series rules. So as I understand what I believe Mr. Joel from TEP suggested in Rule 208 is that there would be an ability to appeal a determination that what an operator thought was a trade secret chemical. So this is sort of in the context of hydraulic fracturing chemicals. The operator thought something should be protected as a trade secret and staff disagreed with that determination, whether there should be an option for appeal to the commission. That option for an appeal to the commission is not currently in Rule 208B. Instead, what Rule 208B provides is that if the director does not agree with the operator's determination, then the director will immediately notify the operator, or if it wasn't the operator, for example, a vendor or service provider, as is often the case with hydraulic fracturing chemicals, is the one who thought it should be protected. That conferral will happen before the information is actually disclosed to the public. So with that background, if you have your binders in front of you, maybe you can flip to Rule 223. And that's sort of our general provision for confidential information, right? That's, this is our more general standard. 208 is only applying to those trade secret chemicals. And you'll see that there's also not an ability to appeal the director's determination about whether something's confidential here as well. And that is explained on the reason for that is explained on page 39 of the Statement of Basis and Purpose. And the reason that staff structured the rules this way is that unlike a court, there isn't necessarily the ability for the commission to do what's called an in-camera review. So that would be sort of a review where the whole commission gets together and looks at a document behind closed doors, so that the actual course of the appeal about should this be confidential or not, which has to be done in a public hearing, doesn't necessarily bring potentially confidential information out into the public. And so the way staff structured Rule 223 was to just say that it is final agency action when the director makes a determination of confidentiality, which essentially means an operator could sue directly to Denver District Court without having to appeal to the commission about whether the director's determination of confidentiality is correct. So that is how staff has structured it for now. There isn't equivalent language in the Statement of Basis and Purpose for 208, but there could be. And I think in some ways it is up to you whether you would want to try to create an appeal option. I think Mr. Davenport could perhaps provide better advice than I can on sort of what in-camera review could look like, that confidential non-public review, if there is an appeal to the commission, or if there's a way to build that into the 500 series, if that's your direction. But for now, that's how staff structured it. And the reason for that is simply to avoid having those confidentiality determinations being made in a public hearing.
Thank you for that information. Does that information engender questions or statements from commissioners?
Mr. Chair.
Gonzalez, yes.
Yeah, so I appreciate Mr. Jewell bringing this up whatever day that was. I had similar concerns when I read the rules and the SBP as well. I appreciate the ability to appeal this even if it's not to the commission. And so I'm not necessarily sure that we need an amendment to this particular rule. But I do believe that there should be due process along the way, and if that is through the district courts, and that is through the district courts, and if one of the vendor companies, the supply companies, the operator, wants to sue and do some sort of temporary injunction or whatever mode they want to, that's their prerogative. I don't know that we as commissioners, the five of us, could do a better job of determining what should and shouldn't be confidential better than the director and the staff could. So that's kind of my 2 cents on that matter.
Very good. I'm comfortable with this where we are as well here. AG Minor, do you want to follow up?
Yeah, well, thank you, Mr. Chair. I might suggest perhaps to Director Murphy and Commissioner Gonzalez, correct me if I'm wrong, but perhaps it could be helpful if staff added parallel language to that. Sort of there is a district court appeal available to the SBP in Rule 208, so it's not only in Rule 223, and that's just clear for everybody that it is staff's intent to put it there. I think it may have been an oversight not to put that parallel language in Rule 208 as well, SBP.
Works for me. Next, Director Murphy.
Great. Apologies. So I think this takes us to Rule 218 and also kind of this question of retroactivity. I think that there are 3 pretty specific questions to go to the legal team among these 2 topics. I would trying to think about the best way to tackle kind of the different topics. I get a little bit nervous about the financial ability request. I think it's a good principle, but it is not something that we have in-house expertise to truly evaluate. So is it a certification or is it truly an in-depth review? And so that is something I think that we'll need to consider and weigh. I think that we are, and we actually, a number of staff members spent time over the lunch hour trying to work through some of the suggestions to improve the 218 transfer process. And so I think we would continue to work on that, and then also look at the question about notice to local governments. So I would just say that those are the first and third bullet points within 218 are something that we can tackle and take a look at. The other questions to me really kind of fall into the legal shop. And so I don't know if I just want to hand it off to the AAGs at this point in time, or if we want to talk about some of the other three pieces that I started in on in a somewhat circular, slightly disorganized way.
Commissioner Messner, sorry.
So I think I was following you, Director Murphy, for a little while, but I think you might have lost me. So are we talking about financial ability, or are we going to let the AAGs kind of jump in on those and then maybe comment after that, or what do you think?
I think I gave you my kind of perspective on the financial ability analysis and certification and what that could mean or look like. I think that if AAGs have more to weigh in on it, I would welcome them to the joint and several liability, the transfer of non-Indian assets, and then the ever-present retroactivity, future applicability question, for me is also an AAG question. So
Okay, copy that.
Yep. Do we want to go issue by issue or just like lump it all together? You tell me.
Well, I wanted to talk a little bit about financial ability because and some of these are just going to be questions in general because I think I'm needing some help reminding myself about what's possible, what's not possible. The analysis of financial ability versus financial assurance, which I do believe are two different things. And so I think, and I think some of the testimony I'm hearing is conflating things as well. And so that does confuse me a little bit. But in this particular instance, I think what the questions that are being asked is, does the COGCC play a role in determining the financial ability of an operator to acquire or transfer assets to another operator? Is that the gist of the questions, the way that everyone else understands it, versus the financial assurance piece, which is more common in land use that I'm aware of, whereas does the operator have the financial ability to do the project, and are they going to bond for at least 100% or 125% of the project costs, right? So does that make sense?
Chair.
Director Murphy?
Thanks. I think you've drawn the correct distinction, Commissioner, in terms of the financial assurance question, the bonding question, the how does the commission deal with that issue is built into COGCC 700 series, and that's not something that we have prepped or is before you. It is a critically important topic across Colorado for any number of reasons. It's an area we put a lot of work into, but we haven't kind of done the final piece, and so we really are looking forward to that rulemaking, quite frankly, and it is one required by 181. So it's, I hope it follows hot on the heels of this work. The more nuanced question about the financial ability or capability of an operator to operate, and now I'm reusing the same words 3 times in a row, is more nuanced, more difficult, and not something that our agency has done historically. I think if we want to talk about, we don't have economists on staff. We don't dig into the financial wherewithal questions. I think that we have upon occasion, and I think either AG Minor or even Ms. Larson may be able to delve into that in greater detail in terms of what it is we are looking at when we're looking at a transfer. So with that, I may hand it off to Ms. Larson, if that is okay with the team.
Ms. Larson.
Yes, excuse me. Thank you, Director Murphy. So just a few additional comments. With respect to the Form 9 process that staff is proposing, we have sought to account for a review of current, for instance, current environmental issues that may be existing on a location. And through that process of seeing what a proposed seller is seeking to transfer to a proposed buyer, staff anticipates working with both parties to identify what outstanding, for instance, remediation projects may be out there, also identifying what staff believes the adequate financial assurance will be for the properties that are proposed to be transferred. And through that Form 9 process, ensuring that the agency has the proper financial assurances coming in, and that any known or anticipated environmental remediation projects are being addressed and are being taken on by either the buyer of those properties or will be retained by the seller. So the language that we have proposed in there contemplates that process and contemplates that staff will be able to ensure that any proposed transfer of a permit is going to comply with our commission's current rules in effect at that time.
Thank you, Ms. Larson, Ms. McGowan, and then Commissioner Nanjapa.
Thank you, Mr. Chair. And I don't know if staff knows the answer to this question, but is there some sort of a correlation to a business's ability to get financial assurance related to its financial health? So for example, if I'm a bank backing up the financial assurance, am I going to look into the fiscal health of that operator before I'm talking way out of my sandbox. And so I'm just asking if there's a relationship there. And then I guess my second question is, are there other instances where a state government entity would look at the health of an organization or business before allowing it to do something? I mean, is there a parallel somewhere else where we would look at the financial health of somebody before we said, yeah, it's okay for you to get a permit or to?
Here, if I may.
They're really big questions, so I understand if we don't know the answers right now, but there are things that are in my head.
Director Murphy.
Thank you. I think Ms. Larson may have more to offer on this. In my experience, the answer to your second question, Commissioner, is no. And so I think that I'm not aware of it. That doesn't mean it doesn't exist, especially as we consider the breadth of regulatory agencies across the United States or across the world, right? The answer to the kind of first question in terms of financial assurance, I can relate to you what I have heard over the course of my experience working on questions around financial assurance and bonding. And what I have heard is that financial sureties or other insurance-based agreements to provide that would satisfy our financial assurance requirements provided by an insurance company, a bank, et cetera, become more expensive based on the bank or the insurer's perceived level of risk. And so in some instances, and I don't know if this is because of the cost of the surety or because it's the operator's independent choice. In some cases, we have cash bonds or what we call cash bonds, which means we have like the exact dollar amount in an escrow account generating interest to cover an operator's financial assurance. Those aren't as common because it clearly ties up a lot more capital than, say, a financial surety would, which I have heard quoted costs anywhere from 2% of the amount guaranteed to 100% of the amount guaranteed, depending on the different entity applying for it. And again, I'm relaying to you what I have heard in the construct of a number of other conversations. So I don't have the true, I know this is a fact and this is how it works either. And so I think so yes, it seems that there is some relationship. Do I know what it is? No. Does it depend on a lot of things I don't understand? Yes.
Commissioner Putnam.
Thank you, Mr. Chair. I think just supplementing Director Murphy's response in response to Commissioner McGowan's question, across the state, we do some functions where we evaluate the kind of financial or technical capacity of entities to undertake various things. So at CDPHE, for example, to get drinking water revolving funds, you have to show the technical and financial capacity to provide clean water and perform that function. So we do have some ability and tools to do that. It's a different context. It's usually public entities rather than private, for example, although not exclusively. CDOT will often do that for some bidding into really big projects. It doesn't make sense to hire a contractor if they don't have the financial ability to follow through. So again, we have tools, although the usual way that that's dealt with, kind of consistent with Director Murphy's point, is through the financial assurances. If you can get the bonds, if you can get the letter of credit, if you could get the other tools, that covers, the State Department could cover the need here, and generally a bank or others are not going to provide those instruments unless they go through that financial analysis. So in some ways, some of this may be bundled up with our assessment of the 700 series in terms of the adequacy of those financial assurances, which is something we very much need to take up.
Thank you, Commissioner Putnam. Commissioner Najapa.
Thank you, Mr. Chair. Yeah, and just kind of adding to this whole conversation, I'm just wondering, and would want to hear from staff, but I mean, just based on what Ms. Larson had just clarified, as far as I can tell, unless I'm missing it. Oh, actually, I think I may have just found it in the rules about the financial assurance. Just how that connects back to what we have required separately in the 700 series. If that's, maybe that could be, I'm wondering if that could or should be part of the attestations. But then there was also a note that was raised, and I'm trying to remember, it may have also been by La Plata and San Miguel, about whether the new owner or whoever's going to continue to maintain the particular facilities have also complied with the local requirements. This may already fall, I'll look to AAGs on this, but this may already fall under sort of our more blanket requirement that anything has to be in compliance with other laws. I just wanted to kind of make sure we have all that covered.
If I may, Mr. Chair.
Meyer.
Yes, so I think Commissioner Nanjapa, I'll take the first part of your question, and it sounds like you've walked through Rule 218 and see where all these pieces are, but just so folks following along at home have as well. I'll just highlight that there are a couple places where the adequacy of the financial assurance is addressed in Rule 218 as currently proposed. So one is in, I believe, 218 B5, and so this is essentially listing what will be on the Form 9, and that does include the amount of financial assurance that the successor in interest would need to submit. So that's kind of getting a sense, making sure that, in fact, not only the commission staff, but also the successor in interest is sort of aware of the scope of the obligations they would be taking on. And then to the point that Ms. Larson was making earlier, if we look at 218E, that these are the things that staff would look at in the course of approving or denying the Form 9. Again, this is as currently proposed, not incorporating any changes to the rule, but you can see that two of those criteria, one is that the permits listed for transfer are in compliance. So that gets to the sort of, do you have a pending enforcement action against you about a open remediation project, that type of environmental issue that Ms. Larson mentioned, as well as whether the successor in interest has actually submitted the financial assurance that's required. And this gets to sort of the timing of what gets done when, but there are multiple checks built into 218, as you noted, in terms of both the financial assurance and compliance with the Commission's rules. If I recall the earlier presentation from La Plata County and San Miguel County, as well as my recollection of their pre-hearing statements, I believe that they were specifically asking for was that there be some sort of indication that the operator was current on their local tax payments built into the Form 9. I can tell you staff didn't take that direction because that would be a fairly complex thing for staff to verify, not necessarily having easy access to sort of county tax records. So that was my understanding of their request, but I may have missed some nuances there, and happy to answer further questions, or perhaps we can bring on Ms. Stanzik or anyone else who would be more familiar with it than I was.
Further follow-up? No, okay. Commissioner Gonzalez. Oh, you just moved. I thought you were moving to unmute. Sorry.
I moved, but nothing on the financial ability piece just yet. So I'll
Any
wait.
further commentary on the financial ability?
Yeah, I've got one if I could, Mr. Chair.
Okay.
So I would, I guess, I would want to ask, how difficult it would be to find out whether or not that operator is fully paid on their taxes before transfer, because my understanding, it's a phone call to the county treasurer. So it doesn't seem that difficult, but maybe I'm wrong. So I'd like a little more information about that. And it doesn't have to be right now, but at some point.
Commissioner Messer, sorry, Chair.
Yep. Director
Commissioner
Murphy,
Messer,
and then Ms. McGowan.
thanks. The scope of that, Commissioner, could get pretty big when you think about the number of counties across Colorado, across a number of other states, depending on how big the operator is and where their operations are. And also the other component of that is to what end. I think it's important for us to know, but what are we going to do about it as an organization? And so divining that line is important for me to think about, and we can sure take a look at it or think about it further. But those are kind of my initial qualms.
And I appreciate that. I just wanted to hear a little more about it because, but I think that your comment about to what end is fair. Yeah.
Thank you, Commissioner McGowan.
Thank you, Mr. Chair. So to continue this conversation, I'm sorry, if as requested for us to look at was letting the local government know before a Form 9 was complete, it would potentially give the local government the opportunity, the onus is on the local government then to say, this is an operator who's in bad standing in our county, and we don't want to transfer more assets to them because they're not making good on their current requirements. And again, maybe that's too complicated and too complex, but it does allow a local government the opportunity to maybe raise a warning flag and say, hey, we have concerns about this operator's, how they're currently operating within our jurisdiction and meeting their obligations.
Do staff or AAGs or Ms. Larson desire to weigh in?
Mr. Chair, if I may.
Yes.
Yeah, just one comment. Thank you, Commissioner McGowan. That's a helpful comment. I would just note out that we're not able to give an opinion or issue any sort of edict as it relates to the actual transfer of the assets. So what may or may not occur in the course of a private transaction, our authority really comes in as it relates to our permits and ensuring that whoever the successor in interest, the buyer of those assets, is will be held to the standards that are in place in our rules as it relates to those permits upon their acquisition, and that we are satisfied that we have the proper financial assurance in place for that operator, that buyer, to operate those locations and those wells.
Commissioner McGowan, follow up?
So sorry, I know I keep coming back to this maybe misunderstanding or wanting to clarify it. Would we have the authority to say before we would sign off on a Form 9? So I guess I'm asking you, would we even have the authority to deny a the transfer of assets based on an outstanding tax debt, for example, for a local government?
Ms. Larson.
Thank you. So I will certainly ask our AAGs to weigh in on this as well. But I can tell you, as what staff has done with our proposed rules, is we have ensured that the director has the authority to deny that Form 9A if the buyer of these locations and wells fails to submit their financial assurance. So again, we're not able to get into whether or not those assets actually transfer in the course of that private transaction, but we can deny that 9A, and the regulatory responsibility of those locations would remain with that seller until that financial assurance comes in and staff is satisfied that it's sufficient for that those properties, and then that buyer to then operate those properties.
Commissioner McGowan, further follow-up? Seeing none. Do other AAG Minor, would you like to weigh in?
No, well, yes, I would. I think I just want to make sure that there's a common understanding that I think by Director Murphy having listed notice to local governments in the staff direction in the rule, that staff can work on ensuring that the relevant local governments where the transferable items are located receive notice at the time that the Form 9 is submitted, which I think is what I hear Commissioner McGowan saying, which is perhaps different than what might otherwise ordinarily happen of a local government having the ability to opt in to get notice when a form is approved, which Ms. Stanzik or Ms. Larson or anyone else can correct me if I got that wrong, but I just want to make sure we're clear on that direction to staff so that staff knows what to do going forward.
Thank you, Mr. Minor. Others with thoughts? We exhaustively beat this horse. Are we in good shape? Director Murphy, do you have direction?
I think I have direction on the first 3 sub-bullets under 218. I don't think we've had the opportunity to discuss joint and several liability, transfer of non-Indian assets, and the question of retroactivity. And with that, I would probably just say, dear AAG Minor, you want to jump in and tackle as much as you can, and then we'll work through these issues and make sure we do get to a good space on these with Commissioner direction.
Yes, thank you, Director Murphy. I will, and I may call on Mr. Davenport throughout the course to see if he has anything to add or a different view. I might start with what I think is probably the easiest question in some ways legally, which is the question of when an asset is transferred from a non-Indian operator that is operating on surface estate and mineral estate that is both controlled in fee by a non-tribal entity within the exterior boundaries of the Southern Ute Indian Reservation. I used each of those terms very carefully because that is the only limited situation in which the Commission would have jurisdiction to essentially regulate oil and gas operations that are occurring within what could legally be referred to as Indian country, so the exterior boundaries of the Southern Ute Reservation. And as I think I've said at various other points during this hearing, this goes back to the fact that in the late 1800s and early 1900s, portions of the Southern Ute Indian Reservation were allotted, which means that they were essentially lost some of their status as tribal assets under the law, and through subsequent transfers of ownership may have sort of lost their status as Indian country. However, the Southern Indian Tribe has a tribally owned oil and gas company that is essentially an entity of the tribal government that sometimes may become the operator for those parcels of land that would otherwise be under the commission's jurisdiction. So I think I'll now just sort of read to you the language from the Oil and Gas Conservation Act that's relevant here. This is section 3460-105 subpart 4A, which says that nothing in this Article 60, so nothing in the Oil and Gas Conservation Act, authorizes the state or its local governments, including the commission, boards of county commissioners, and municipalities, to regulate the activities of federally recognized Indian tribes, their political subdivisions, or tribally controlled affiliates, undertaken or to be undertaken with respect to mineral evaluation, exploration, or development on lands within the exterior boundaries of an Indian reservation located within the state. So that was a lot of legal terminology, but what it means is that if a entity controlled by the Southern or any other tribal government takes control of an operation that is otherwise within Indian country, the commission loses its regulatory jurisdiction. I would interpret that to mean that staff could not somehow make the financial assurance associated with the site run with the land, as was suggested by Lapota County. I'm not sure that exactly what that means legally, but I don't think that we can continue to apply a financial assurance requirement that would otherwise apply when a tribally owned entity takes over an operation, because the commission would lose its jurisdiction over all parts of that oil and gas operation, including the financial assurance. So I hope that makes sense, and I'm happy to take follow-up questions on that, or Mr. Davenport can weigh in as well, but that would be my interpretation of that legal question.
Mr. Davenport, did you want to?
Thank you, Mr. Chair. I don't have anything to add to what Mr. Miner said. I agree with his interpretation, and I agree.
And having practiced law in Southwest Colorado and worked with the Southern Indian Tribe and been an attorney for the county within which the Indian country is located, I agree with Attorney General Miner's perspective on that issue. Further discussion, debate on that issue? Seeing none, do you want to go to the next issue, Mr. Miner? Oh,
Certainly.
Mr. Gonzalez. Actually, hold on, we got one.
No, I just want to make sure we were going to stay on 218 before moving on to another rule. So I'll let AAG Minor finish what he's talking about, and then I think one of the concerns about the first bullet point with industry above financial ability we haven't gotten to that I want to talk about is the timing for 9s and 9As. But we can come back to that. Just want to make sure we didn't move on too fast.
AAG Minor.
Thank you, Mr. Chair. So I apologize, I did not get this called up quite as quickly as I would like. It is my opinion that the Oil and Gas Conservation Act does not allow the creation of joint and several liability upon the transfer of an asset. And the reason for that is part of the statute. So this is Colorado Revised Statute, section 3460-124, subpart 9, states that each responsible party shall be liable only for a proportionate share of any costs imposed under this section, and shall not be held jointly and severally liable for such costs. And I want to emphasize that this is sort of in the narrow context of a responsible party determination. So how that relates to sort of the broader question of what is and is not established in the course of a transfer, I think it is a nuanced question that we can get more into, but I'm not sure that a blanket requirement of joint and several liability that is adopted upon a transfer would be completely consistent with that section of the Act. So that is my reading of it, and I would then perhaps see if Mr. Davenport has anything he'd like to add or reads that provision any differently than I do.
Mr. Davenport.
Thank you, Mr. Chair. Thank you, Mr. Miner. I agree with Mr. Miner's interpretation. You know, I think when we joint and severable liability is a broad term, and I think it's been used by the parties in a variety of different contexts. I think that when some folks are referring to that, they're referring to more of a CERCLA style liability for a particular oil and gas facility. And in my view, the commission does not have the authority pursuant to the act to attach that kind of liability, that we still have to pay attention to the responsible party provisions of the act. But as Mr. Miner said, it's much more nuanced to talk about transfers of assets and enforcement in context of a location that has had numerous different operators. So Mr. Miner and myself will continue to work with staff on Rule 218A and get that to the best place possible for the commission.
Thank you, Mr. Davenport. And I'll just continue by saying part of what staff attempted to do in crafting Rule 218 was perhaps avoid complex questions of joint and several liability coming up later by establishing a clear demarcation of which operator is responsible for what at the time of transfer. Which means that you're sort of having to look at it later and just be like, I don't know, each of you are liable, you figure it out, sort of. I don't want to sort of make that was perhaps too not a fair characterization of CERCLA liability. But I think what staff was trying to do is avoid those complex questions where something like joint and several liability might need to be raised by getting more clarity upfront through the Rule 218 as proposed.
Oops. Thank you to our Assistant Attorney Generals for that perspective. I, as one commissioner, am comfortable if you guys are going to work through that and get it to the best place possible and bring it back. That makes sense to me. Other commissioners with Okay, I'm not seeing any other commissioners with issues on that. AG Minor, are you back up or?
I think Commissioner Gonzalez was hoping to address one more point on 218, I believe he said, before we moved on to the sort of retroactivity question. Is that correct, Mr. Chair?
Commissioner Gonzalez.
Thank you, Mr. Chair. Yeah, there was some commentary. I don't recall if it was from industry groups or which one exactly made this, but it was another concern that I had shared in reading through the rules and the statement of draft, the draft statement of basis and purpose. In regards to the timing for the Form 9s, I've done plenty of transactions in Colorado regarding properties, regarding mineral rights, et cetera. And I know from my experience that a lot of those have changes in the actual properties up to the date of closing. And so I'm curious about what is driving the 30-day pre-closing timing and what staff needs out of that 30 days, because the actual conveyance of the property itself can't be stopped by the commission of the transfer of the actual permits and the different forms and the facilities through the COGCC. So I'd like staff and maybe AAG Minor to give me some more background on that I may have missed through the statement of basis and purpose, or that I'm not interpreting the rule correctly.
AAG Minor.
Thank you, Mr. Chair. I can give you some context about staff's intent there, Commissioner Gonzalez, which I think was based on the concept of a lot of the review being done on the Form 9, right? What happens beforehand, not necessarily what happens after, which is the 9A, after the transaction is closed. Staff did need time to review what could be hundreds of individual items being transferred. I think that if the direction staff is hearing is that maybe more of that individual review is happening on the 9A, right, which would be after the closing has happened, then the timing issue becomes very different. I do want to make clear, though, that sort of part of the purpose of the Form 9 in staff's mind is making sure that the buying operator, the successor in interest, is aware of what they're buying. So that there's some value in that, in them getting some advance notice of that. But the 30 days as built into the current rule was really staff's attempt to make sure there's enough time to review what could be a lot of information, and all of that would become essentially a very different picture if industry's changes are built in, which I think staff is very prepared to do.
Thank you, AG Minor. Yeah, and I totally appreciate the need for transparency, the problems that exist with the transfers that have happened in the past. I read that 30 days and I read the Form 9 and I think, well, if there's some defect in the due diligence period under a PSA, and that's usually cured within 10 days of closing, give or take, depending on the contract itself. But when you get out there and you defect something, and the other operator, the buyer or the seller says, well, hey, let me add in these real quick and let's stick with our closing date, they would inevitably, if they stuck with that closing date, be out of compliance through Form 9. And just given the amount of times I've seen that happen in my career alone, which is limited, and I'm talking, we're making regulations for the whole state and for all transactions in this regard. I think that it'd be really, really impactful and important to not put a seller in out of compliance for last minute changes at the closing date for those types of transactions, because they are private property transactions. And if the idea is to protect the buyer, that's on the buyer during those contractual negotiations to make sure their PSA protects them from that. PSA is a purchase and sale agreement, in case I didn't say that. I know I'm throwing out acronyms here. And so that's a concern I share, and I think it could use some more flexibility in the timing and the requirements for the 9 and the 9A.
Sure.
Director Murphy, thank you.
Thanks. Commissioner Gonzalez, your point is well taken. And I mean, I think the goal is really to get the bulk of the transferred items early on so that you can work in good faith with those kind of last minute changes. But if we're talking about transferring 1,000 wells and associated facilities, like, if we get most of it, that puts us a long way ahead in terms of actually managing the transfer and making sure we know where things are going, and we can work with those changes. And we are going to take a hard look at industry's changes on this and get back to you all.
Thank you, Director Murphy. Others wanting to weigh in here? All right, I'll turn it back to you, Director Murphy.
Thanks for your patience. I thought I should acknowledge that note very specifically to myself, because I tend to forget things about 15 minutes after they happen these days. So hopefully that captures it. So with that, I would turn it over to what I believe is the last issue to resolve in the 200 series based on today's discussion, and that is around La Plata County's comments around retroactivity. And from staff's perspective, at least, I think that we have, as we've looked at each of these different rule series, looked to what we believe should be retroactive or not. And I think we want to strike a very fine balance around looking at what can and should be updated to comply with 181, and also, but not going so far as to staff re-evaluating an existing facility for its potential impacts. And I think some of the requests we heard this morning could trend in that direction. And so we're trying to strike the right balance, make sure that some things are updated as required, and also that some facilities, as they are modified or changed significantly, do come also into compliance. But I don't think we have much appetite to re-permit a facility, for example, anew, short of a substantial change again. So with that, AAG Minor, you may provide more precision or specificity than my very, very broad gloss.
Certainly, thank you, Director Murphy. I think the specificity I would provide is just a request for more specificity, perhaps from Commissioner Nanjapa, who I think raised this in the context of the 200 series, or other commissioners. As I mentioned while you were speaking with La Plata County earlier, staff did read La Plata County and San Miguel County's filings, just as with all parties, and certainly saw their feedback on retroactivity and in applying to existing facilities, and had that in mind, just as staff had similar feedback from industry in mind about what is and is not retroactive and what applies to existing facilities throughout the rules, and tried to do the best job that staff could on being clear about what is and is not retroactive and what does and does not apply to existing facilities. I can say it certainly helped me to hear more specific examples from La Plata County this morning. And if there are other areas that that commissioners feel there needs to be either more clarity or a change from something that currently applies only to new facilities to instead apply to existing facilities, I think staff is very open to that direction. But I think this is an area where we really do need some very specific guidance from the commission, because taking sort of a broad approach doesn't necessarily work with something that is as nuanced as this question. And I also, since this may be the last question I answer, I just want to correct the record on something I said earlier. I think I went back and looked at my notes from what Mr. Jewell from TEP was saying, and I do think that a lot of his questions about sort of the confidentiality appeal were maybe less in the context of chemicals and more in the context of some other broader categories of information that could be confidential. And I just wanted the record to reflect that I didn't necessarily characterize his statements correctly. So with that, if there is feedback from the commissioners on things that you'd like staff to look at, I think that would be very welcome.
Feedback from commissioners. Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you, AG Minor. I appreciate and acknowledge the amount of work you all have done in terms of looking at, you know, all these different pieces and whether or not they should apply retroactively. And I guess I'm thinking, you know, as I mentioned, some of the wildlife related considerations, but maybe also some of the nuisance related issues. We also heard from 350 Colorado about, you know, additional concerns of, they were talking more about orphan wells and you know, other improperly plugged facilities, but, you know, kind of thinking about all of those things, and just the idea that an older facility, and we heard about all these great technological advances that newer facilities have, but the older facilities are probably going to be bigger, I shouldn't say probably, but could be in certain instances bigger contributors to public health, welfare, safety, environment and wildlife concerns. So I totally, again, appreciate that. I'm sure you all wrestled with this, but I am wondering if, or maybe I should just ask and make sure that I understand that any ongoing operations would still be subject to the new rules. So things that would relate to some of those nuisance issues of lighting, noise, et cetera, the new rules would apply. Is that correct? But it's more like other, you know, major modifications to the facility, as you noted, you know, like if it was going to be moved or something. I know that came up in that discussion with La Plata and San Miguel, that it's not so much that they're trying to, you know, relocate or rebuild or re-permit even, but, you know, what are the ways in which we can ensure those older facilities, which are potentially more problematic, are being addressed, and maybe you can just help me understand related to those aspects.
Okay, AG Minor.
Thank you, Mr. Chair. Yes, I can. And I think that this goes to what, again, maybe staff could have explained better at the beginning of the 400 series, which is that the 400 series are our operations rules. So for the most part, and there are exceptions, those govern ongoing operations and conduct. So I think you can generally assume that unless it specified otherwise, that what you see in the 400 series applies going forward, that this applies to ongoing operations at both new and existing facilities. And I'll come back to the nuisance piece in a moment. The 600 rules are safety rules, and many of those rules govern equipment construction. And so I think that that's where sort of more things don't apply to existing facilities, right? Because to comply with the new equipment building standards, you would need to essentially retrofit existing equipment which staff generally did not require in the proposed rules, though of course we can take your direction if there are places we missed that it should apply to existing facilities and require retrofit, except for the limited exceptions I mentioned the other day. So just taking an example of a type of equipment that maybe could have been designed better in the past, thinking about partially buried tanks, staff did strengthen the safety and environmental protection standards for partially buried tanks, but did not necessarily propose that operators need to remove all tanks that are currently partially buried and retrofit them. However, again, thinking about those equipment standards, when there are significant changes made to a site, that might be a reason that, as we've discussed before, secondary containment is added, which could potentially be beneath the partially buried tanks if those are on site, if that's one that's modified. So I think the noise rule is a good example to think about for how staff structured the ongoing operations. So if you look at 423, which is the noise rule, 423A is a plan, right? That is something that would only apply to new facilities because it says when an operator submits a Form 2A, so request for a new location or just significantly modify an existing location, they submit that plan. But essentially the rest of 423 involves operational standards, right? Saying operators need to comply with these noise standards. And as I mentioned earlier, the table you see there that sets noise limits in different areas, except for the C-scale noise, the DBC, that was all in the existing rules, right? That's, I believe, current Rule 802. And so operators have been responsible for complying with current noise standards, and new operations that are ongoing would need to similarly comply with the operational standards throughout the nuisance rules. I left out, when I was discussing La Plata County's in feedback earlier today, you'll note I left out visual impact mitigation. And that's because that's really an equipment standard as currently written. It says how you paint your tanks or other facilities. And that would be an example of something that would require essentially a retrofit repainting or perhaps reorienting. But the other nuisance rules are sort of standards that apply to ongoing conduct, right? Any new source of odor or dust or noise or light, when someone turns on a light or drives a truck on a site and stirs up dust, that's an ongoing operation. So I hope that provides some clarity, again, about how staff put things together, but that doesn't mean that staff can't obviously take your direction on areas that we need to take a more close look at, either providing more clarity in the text of the rule or changing what is currently perhaps only applying to a new facility to also apply to existing facilities.
A follow-up, Commissioner Manjapa?
Thank you, Mr. Chair. Thank you, AG Minor. No, I think that really helps. My mind is going back to some of the conversations we had in earlier series with respect to like the comprehensive area plans, or even as we think about things like variances, whether there are additional items we can request or provide as incentives for, either doing a comprehensive area plan or other things. For example, doing some retrofits to some of these older facilities, or doing additional mitigation to facilities that are within the area. So that's not specific to this rule set, but I just want to put that out there for the other commissioners to think about as we go into the broader deliberations.
Commissioner Messner, I believe you had your hand raised.
Thank you, Mr. Chair. So this got me thinking a little bit, and I'm trying to just understand how this retroactivity would apply, particularly around the nuisance issues, but around all the issues. And I do want to commend staff for how they analyzed how rules would be retroactive versus on prospective operations, because as I read through there, I found it incredibly logical and it makes sense. And, I think it actually applies really well. However, as I listened to the city of Greeley's testimony today, where they, are proposing having subdivisions butt up, relatively close to an existing operation, is that existing operation have to meet some of these nuisance standards, even though it's the local government that is placing the houses in closer proximity to the oil and gas location than the COGCC?
AG Minor.
Thank you, Mr. Chair. Commissioner Mesner, that is perhaps one of the toughest questions, and I didn't quite have time to find this, but it is something that I believe staff did address in the statement of basis and purpose. I think perhaps in the section for Rule 423, and I'm sorry, I don't have the exact page site. And there is an expectation that essentially the site is grandfathered in if the house comes later. And I'm pausing and I'm trying to think about whether to say receptor. I think that would probably also, that might not actually also be true for wildlife, since those migrate a little more. I think we covered that in other ways. That, and I do want to underscore that our rules do not preclude any remedies that might be available at common law between a homeowner of a home that is built after an oil and gas operation and the oil and gas operator, if they believe that there is in fact a nuisance, right? I think Colorado law would spell that out in civil court. We are adopting rules that we call our nuisance rules, but those don't necessarily foreclose private nuisance suits. But there would not, I think we did intend for the nuisance rules to be structured such as that if a essentially new house comes in later within proximity, there wouldn't be sort of a change to the operator's compliance obligations. Does that answer your question?
It does. No, and I appreciate that, because I do think, particularly in areas where there is, established mature oil and gas locations, the homes may very well have come in after the oil and gas operation. And that actually, I think that, like I said, you guys took, I think a very logical approach on how you were going to apply these different rules in the 400 series and the 200 series retroactively versus prospectively. And so I do really appreciate that. And there is a role for local government, particularly if the local government permitted housing activity after the oil and gas activity, to take some regulatory responsibility to addressing some of those issues as well. So.
Thank you, Commissioner Messner. Other commissioners with thoughts? All right, I'm not seeing any. Going once, twice. Director Murphy.
I think we have direction very specifically on Rule 218 to revise rules. I'll probably leave it to AG Minor's good judgment about what to capture of this dialogue and the statement of basis and purpose. And with that, I would say, I would venture to say that we've completed the proposed review of the 200 through 600 rules at 2:30 in the afternoon on September 10th, subject to getting revisions back from staff and kind of taking one last cleanup. And that is remarkable. I'm like a little bit floored by it right now. I know that we have a little bit more on our agenda today and more to cover on these topics. I do think that the commissioners and parties should think about whether we have a end of deliberations, hold up your, COVID support creature, right? Who are we cohabitating with? Your pets, your dogs, your kids, and then whatever your beverage of choice is, to toast each one of us who've worked through an incredible amount of stuff in a really unique environment. But that is my probably social butterfly showing. So with that, I would say perhaps we turn to the OCT petition. Nope, we're gonna take a break. Yeah, that's an even better idea.
Why don't we take our mid-afternoon break? It's 2:31. Let's return at 2:46, and then we'll take up Our Children's Trust presentations. Afternoon, folks. It is 2:46 and a half. So I think we're ready for our final event of the afternoon, which is the presentations around Our Children's Trust rulemaking petition. I think that to sort of kick this off, I might call upon AAG Davenport to sort of frame the rulemaking petition, sort of explain, give some background about it and why it is that we're taking it up and what we should expect. Is that all right, Mr. Davenport?
Of course, Chair. Commissioners, before we hear from the parties on the Our Children's Trust petition for rulemaking, I thought it would be helpful if I explained why we're hearing that petition in the course of this rulemaking. As some background, a petition for rulemaking is a request that an agency conduct a rulemaking. Both the APA and Commission Rule 529 provide that any person may file a petition for rulemaking. Rule 529 requires that the petition include the proposed rule, the reasons for the requested rule, and a proposed statement of basis and purpose for that rule. However, neither the APA nor Rule 529 require the Commission to consider a petition in a specific manner or within a certain amount of time. The only exception is related petitions, which I'll speak to in a minute. For those, the APA provides a little more, but not much guidance still. And before I talk about the petition specifically, I'd like to back up even more and provide some context. Senate Bill 181 became law on April 16, 2019, when Governor Polis signed the bill. In the summer and fall of 2019, the new Volunteer Commission embarked on a statewide listening tour to hear from the public on mission change, cumulative impacts, alternative location analysis, and flow lines. That listening tour included lengthy public comment sessions in Glenwood Springs, Thornton, and Erie, as well as numerous discussions between then Director Robbins and the Volunteer Commission on the rulemaking process and contemplated procedure for the rulemaking. Also, for most of 2019, then Director Robbins and COGCC staff solicited input on policy and rule changes from stakeholders, and the staff submitted numerous rule change suggestions. Then, on November 1st, 2019, COGCC staff released the Mission Change White Paper. The White Paper provided stakeholders and the public with their first look at staff's contemplated rule changes to implement the mission change. I describe this history because I think it's important to understand that the mission change rulemaking was well underway by the time Our Children's Trust, or OTC, filed its petition for rulemaking on November 8, 2019. Which leads me to explaining why the OTC petition is under consideration in this rulemaking. Section 24.4.103, which is the rulemaking provisions of the APA, provides that while action on any petition is within the discretion of the agency, and this is the quote from that statute, when an agency undertakes rulemaking on any matter, all related petitions for the issuance, amendment, or repeal of rules on such matter shall be considered and acted upon in the same proceeding. I know you've all read OTC's petition, so I will only provide my opinion that the petition is related to this rulemaking because it proposes rules intended to protect public health, safety, welfare, and the environment and wildlife resources, and address and evaluate cumulative impacts. In recognition of this provision of the APA, on June 25th, 2020, the Commission hearing officer for this rulemaking issued an amended case management order, which notified all parties that the Commission would consider the OTC petition in this rulemaking. That amended CMO also allowed the parties to file responses to the OTC petition. 15 parties filed such responses. On August 7th, the hearing officer issued the final pre-hearing order, which grouped parties for presentations and allocated presentation time to each party or party group. That final pre-hearing order also granted parties leave to file a motion by no later than August 18 if they were omitted from the presentation schedule or disagreed with the party grouping. On August 18, OTC filed a motion requesting permission to file a reply to the responses to the petition and requested additional presentation time for itself and any party who filed a response. The hearing officer denied OTC's motion in part and granted it in part. The hearing officer denied OTC's request for reply as not within the motions allowed by the final rehearing order and as it was untimely. However, the hearing officer granted OTC's request for additional presentation time and allotted 5 additional minutes to OTC to address its petition and 2 additional minutes to any party who filed a response to OTC's petition. So that's how we got here today. In my view, you should treat the rules proposed in the OTC petition in the same manner as any other rule proposed by any other party in this rulemaking. That is, to consider the rules proposed by OTC and staff's and the party's position on those proposed rules. That ends my description of the procedural posture. I'm happy to answer any questions from the commissioners.
Thank you, Assistant Attorney General Davenport. Do commissioners have any questions at this time? All right, with no questions at this time, Ms. Larson, am I right that we first turn to Earth Guardians and Our Children's Trust for them to present the reply to party responses, and that is a 5-minute presentation?
That is correct.
So we will bring into the House the folks that are associated with that entity. There's Mr. Bellinger. Now we can see Mr. Bellinger. Hello, nice to see you this afternoon.
Hello, thank you. Thank you, Chair Robbins and Commissioner and Assistant Attorney General Davenport for that background. Again, my name is Nathan Bellinger, and I'm here today on behalf of Earth Guardians and Our Children's Trust. And I'd like to thank the Commission for setting aside some time for parties to address the OCT petition during these hearings today. I prepared a presentation for today to try and address some of the topics raised in the various responses to the OCT petition. But as I was reviewing my notes last night, I realized the presentation I had prepared felt too technical and mechanical. And to be honest, I was distracted by other pressing issues that were happening right outside my door. So at the last minute, I decided to change my original presentation. The past 3 days have been extremely challenging here in Oregon. On Monday, numerous wildfires broke out and grew exponentially due to strong winds and abnormally hot and dry conditions. There are now massive fires burning around the state, including one just outside of Eugene, where I live, which has burned an astonishing 150,000 acres in just 3 days. 500,000 acres across the state are burning right now. Tens of thousands of people have been evacuated. Hundreds of homes have been lost. Entire towns have been decimated. And at this point, 3 fatalities are confirmed, although we've been told by our governor to expect a significant increase in the death toll. In Eugene, ash has been raining down on us for the past 3 days, and the sky is filled with dense smoke. The air quality index has been well over the hazardous threshold for 3 days. We have the most toxic and smoky air in the world right now. I have barely been outside, and my young kids have not been outside for 3 days because I don't want to expose their developing lungs, brains, and other organs to the hazardous air. Mandatory evacuations are now to the edge of the urban area where I live. It's been hard to stay focused on work the last couple of days with so much despair and destruction all around me. Unfortunately, my experience is not a unique one, and many others are much worse off right now. This summer, wildfires have been ravaging all western states, including Colorado, and filling our skies with smoke. As you know, Colorado has experienced numerous destructive wildfires, including the Pine Gulch Fire, the largest in the state's history. I honestly haven't been able to keep track of the number of fires, the acres burned, houses lost, and the number of lives upended or shattered this wildfire season. Scientists have long warned us that climate impacts, including abnormally hot and dry conditions, will cause increasingly destructive wildfire seasons, and those warnings are playing out today. Make no mistake, climate change is not a future threat, but the devastating impacts are being experienced right now. So rather than go through the specific responses to the OCT petition, which 5 minutes, quite frankly, isn't enough time to do anyway, I'm here today to ask you to carefully review the factual evidence contained in the OCT petition, explaining how Colorado's oil and gas industry is contributing to the ongoing climate crisis, as well as the evidence in the petition about how the climate crisis is resulting in a public health crisis to which children, including the 65 youth petitioners, are uniquely vulnerable. We don't have time to wait to address greenhouse gas emissions or for incremental progress. As Colorado's General Assembly and scientists have made clear, climate change is causing adverse impacts to Colorado's environment and public health today, and greenhouse gas pollution must be reduced immediately and significantly. It is imperative that the Commission, the sole state agency responsible for regulating the development and production of oil and gas resources, act in accordance with the state's greenhouse gas reduction targets and promulgate rules, such as those proposed in the OCT petition, that will help ensure that the Commission is fulfilling its obligation to protect public health, safety, and welfare of all Coloradans, and especially its youngest citizens, from even more severe impacts of climate change in the future. So, on behalf of the 65 youth petitioners, we respectfully request that the Commission, consistent with its obligation to consider and act upon the OCT petition, as Mr. Davenport noted, pursuant to Colorado Revised Statute 24-4-103, subsection 7, and the amended case management order, we request that the Commission formally consider and act upon the OCT petition and provide the 65 youth petitioners with a formal written response to their petition, so they know that their concerns are being heard and addressed by this Commission. Thank you.
Thank you, Mr. Bellinger. Thoughts and prayers from Colorado are being sent your way. Plus to our Oregon brothers and sisters. I've got family there as well, and I understand the devastation that you guys are facing.
Thank you.
We have historically allowed for commissioner questions during sort of closings. And so if commissioners have questions, now would be the time to ask such questions of Mr. Bellinger. Commissioner McGill.
Thank you, Mr. Chair. Thanks for being here today, Mr. Bellinger. And I have an aunt and uncle living in Oregon, so thinking about you all and hoping that everything's hoping for rain for everybody.
Thank you.
I'm wondering how you see the mission change rulemaking that we're going through right now fitting into the petition. I'll start with that question.
Sure. So we filed the petition for rulemaking back in November 2019 to try and have the proposed rules and the evidence before the Commission as early as possible as it continued with its mission change rulemaking. Since then, we have attempted to incorporate some of our specific changes into the different rule series, as you know, I discussed in the 300 series rule presentation. But as Assistant Attorney General Davenport noted, given that the petition addressed issues that the commission was working on ongoing rulemaking, we think that the commission has an independent obligation to consider and address the petition. And as far as I can tell, that hasn't happened yet. So I think that could include a response that says how the commission thinks the concerns or the proposed rules in the petition are being addressed through changes to the 200 to 600 or 8, 9, and 1200 series rules. So if the commissioners think that the proposed changes are being addressed, again, they're suggested rules, then we would love to hear that. But I think, we would appreciate some type of response about how the commission thinks it's, that indicates that the commission has evaluated both the evidence and the proposed rules.
Other questions? So I think I heard Commissioner McGowan's question was how you felt that all the work that's being done may or may not sort of fit within your asks. And I understand that you're asking us to respond back likewise, but did you want to respond?
So is the question, do I think that the proposed changes being made to the rules so far are addressing our concerns in the petition?
Yeah, I mean, we're doing a lot of there's a lot of effort here.
Oh yeah.
And so yeah, I mean, I guess I would ask that question is, what's your perspective on whether and to what extent some of the effort that you're seeing is addressing some of the requests from your petition?
Okay, yes, thank you. I would be happy to address that. And I would also like to just acknowledge the incredible effort. I know how much time and energy everybody has put into this, not just in the last 3 weeks of the hearings, but in the months leading up to that. And so really appreciate that. I would say a lot of progress has been made over the course of the last several months in the hearings and improving the rules. I think one area that we remained concerned about, although we'll see what happens with the proposed revisions to the rules tomorrow, is the commission's obligation to really evaluate and address the cumulative impacts of oil and gas development, which we believe include greenhouse gas emissions and the industry's contributions to climate change. And so we talked about that quite a bit in the context of the 300 series rules. But one thing so I think there's some progress being made to at least evaluate the greenhouse gas emissions from oil and gas development. But I've yet to see proposed rules that ensure that the commission is making sure that the oil and gas production in the state and the greenhouse gas emissions that result from that production are being reduced in line with the state's greenhouse gas reduction targets. So I would say that's kind of one concern that we still have.
Does that mean that some of the other concerns are being adequately addressed? And I guess I'd put kind of a fine tooth on it. Is 303A5 is the CIDR, and I can't remember what the acronym is, database. And do you have a position as to whether that baseline data aspect, which is gathering data for cumulative impacts, do you have perspective as to the responsiveness to your petition's request for baseline analysis?
Yeah, so I think that CIDR database is a big step in the right direction. At this point, I don't think that it includes greenhouse gas emissions, although I know there was a lot of talk about that in the 300 series rules. So that's one thing we'd like to see added. I also think that it's important to understand the current impacts to resources in Colorado, to really thoroughly evaluate how much additional oil and gas production is consistent with protecting public health and the environment. But I think that CITO database is a very positive step in the right direction to address baseline impacts.
Great, thank you. And thank you for allowing us to have some follow-up discussion with you about the important issues that you raise on behalf of your 65 children.
Yes, thank you.
I'm not seeing other questions from commissioners. Therefore, we thank you. Again, send thoughts as you can. Those thoughts collide with the Pine Gulch fire as they come your way, but we're sending them anyway. All the best, and we'll look forward to your continued participation in our process.
Thank you.
Miss, are we now to? I don't have my map in front of me. Sorry, I lost it amongst my various screens. Miss Larson, can you help me out here?
Yes, so next up we have 350 Colorado, and Ms. Parkin will be presenting on behalf of that entity.
Hi, Commissioners. Good afternoon. If I may ask, I'm having some internet difficulties right now with pulling up my presentation. So I'm wondering if you can push my presentation after the next. Sorry to ask.
With me, Ms. Larson, do you want to potentially go to the next presenter and then give Ms. Parkin time to get her internet squared away?
Certainly, that would be the affiliated local governments, and Ms. Sanchez will be presenting on behalf of that group. Let me get Ms. Sanchez in, and Ms. Parkin, we will put you back to an attendee and call you back after Ms. Sanchez has presented.
Hello, Ms. Sanchez, we can see you.
Okay. All right, should I begin?
The floor is yours.
Okay. The ALGC applauds the OTC petitioners for their strength and tenacity advocating for climate and public health protections. Passionate efforts to protect people on the planet are absolutely called for. These are the most significant issues of our day. All it takes is a look around and recognition of recent events that have occurred, the drastic weather changes we're experiencing, fires all around, high temperatures, high ozone days, and numerous natural disasters, to see that the climate crisis is very real. Moreover, if you had a chance to read the newspaper yesterday evening or this morning, an Associated Press article published indicates that it's going to get a lot worse, despite how that might challenge the imagination. In that article, Colorado University Environmental Science said that the trajectory of worsening disasters and climate change from the burning of coal, oil, and gas is clear and basic physics. We recognize that both COGCC and CDPHE are engaged in rulemakings that address, at least in part, the issues raised by the petitioners. In the current COGCC mission change, we're having a very important discussion around how to address cumulative impacts, which include impacts to climate. A separate rulemaking is currently underway at CDPHE intended to reduce methane emissions and other air pollutants from oil and gas activities. While we appreciate these efforts, it's what comes out of these rules that's going to be important. So we emphasize the need for strong rules that require close analysis of proposed oil and gas facilities, address cumulative impacts, and take a hard look at how to address the broader problems of public health and climate that the petitioners raise. Climate and public health, safety, and welfare are intimately connected and similarly under threat. If we can effectively work on one, we will make progress toward the other. How we address the environmental and public health issues related to oil and gas development in our state are in part how we will get at the problem of climate change. So please don't be timid in your deliberations. Carry forward your ideas for incorporation into the rules. Only bold action will achieve the goals stated by the Governor and the General Assembly to protect public health and address the related climate problems. It's why we're here. We ask that you be part of making the changes that are necessary and do your best for the state of the people in the state. Thank you.
Thank you, Ms. Sanchez. Do commissioners have questions for Ms. Sanchez? All right, seeing none, we appreciate your participation with us this afternoon. We will allow you to be unimpaneled, and Ms. Larson, is Ms. Parkin, is her internet working at this point?
Yes, thank you so much for your patience there. It was failing to, my presentation was failing to load properly, so appreciate your time there.
Do you want to share your screen?
Yes. Let's
Okay.
see. There we go.
Yep.
And I'll pull it up to present mode. Great. Thank you so much. So I'm Micah Parkin, Executive Director of 350 Colorado. I'm speaking today on behalf of these three organizations, including my organization 350 Colorado, which has 20,000 members statewide who are deeply concerned about the climate crisis. As we know, the climate is already changing rapidly, and Coloradans are already suffering from worsening wildfires, droughts, floods, record temperatures, disease, pine beetle epidemics, and economic impacts to our agriculture and winter sports industry. The International Panel on Climate Change 28 report calls for urgent action to phase out fossil fuels, including shifting as quickly as possible in the next decade to be able to avoid greater than a 1.5 degrees Celsius temperature rise. Doctors Anthony Angrafia and Robert Howarth of Cornell University have testified before this commission that their research, as well as NASA and Harvard, shows that as much as 66% of the global methane spike over the last decade is from North American shale oil and gas. We support the points and proposed rules presented by the Our Children's Trust petition, and we urge the Commission to respond to the evidence and proposed rules in the petition. We agree with the youth petitioners that oil and gas development is dangerous, toxic, contributes to climate change, and harms public health, safety, welfare, the environment, and wildlife. We agree that in order to fulfill your mission, the Commission must craft rules to address the oil and gas emissions significantly exacerbating the climate crisis. So we support these various points from the OCT petition, urging you to base all decisions on COGCC's new mission, utilize best available science, including climate science and methane research, address the cumulative environmental and health impacts, support the climate recovery plan, add additional requirements that OCT recommends to, and deny permits if necessary, and establish climate adaptation and mitigation program. In conclusion, we urge the Commission to set rules that align with the OCT petition and to use the precautionary principle, meaning defaulting to a denial unless rigorous standards are met for permits. Additionally, we urge the Commission to begin phasing out new permits 10% per year to help meet state and national goals to stay below IPCC's recommended 1.5 degrees Celsius temperature rise globally. Thank you so much.
Thank you, Ms. Parkin. Do commissioners have questions for Ms. Parkin? Okay, seeing none, thank you for your presentation this afternoon and your participation in our rulemaking. We will unimpanel you, and Ms. Larson will move to the next party.
Yes, and Mr. Chair, our next party is the American Petroleum Institute of Colorado, and unfortunately, I'm not locating currently Mr. Martin, but give me a moment. I think we're going to find him here shortly. And I did. All right.
Good afternoon, Mr. Martin. We can see you.
Good afternoon, Mr. Chairman. Just for the Commission's edification, I've asked Ms. Hackenberry to load this document or the PowerPoint for you because I don't think I know how. So she's going to advance the slides as I go along, if that's all right.
That is perfectly fine. So we have your PowerPoint up now.
Great. And as you can see, I had to move it up, the schedule for preparing this up a bit. So it's not the fanciest PowerPoint you'll ever see. Ms. Hagenberger, would you move to the next slide, please? So in summary, the API Colorado believes that this commission lacks jurisdiction to consider core elements of the OTC petition and that therefore the commission should dismiss the petition. Next slide, Ms. Hackenberry. So the petition actually includes several different proposed rules. As background for several of those proposed rules, the petition would require the commission to conduct a wide-ranging comprehensive baseline assessment of how historic and current oil and gas resources are affecting a number of different values. Next slide, Ms. Hackenberry. At that point, once that baseline calculation has been done, the commission would then have to calculate the lifetime greenhouse gas emissions from both current and historic oil and gas operations and develop greenhouse gas reduction targets consistent with a very complicated formula that actually bears little resemblance to the formula established by statute in Colorado. Next slide, Ms. Hackenberry. Then it would provide that the commission could not issue a permit unless a number of conditions are met. One of them is that the operator would have to show the operation would not injure, destroy, detrimentally affect, or harm a number of different values. And it turns out to be, I think it implies a no adverse impact standard. And then it also requires that the life cycle greenhouse gas emissions would be consistent with the climate recovery plan. And as I read it, that would demand negative emissions from oil and gas operations to secure a permit. Next slide, Ms. Hackenberry. I believe, and you can see our analysis on our pre-filed statements, but I believe the Commission lacks the authority to develop a climate recovery plan, partly because it goes well beyond your own statutory authority. Your authority, I don't believe you have the authority to refuse to issue permits that avoid all adverse impacts or to require an operator to accept a negative emission standard. But more important, I believe that another bill introduced alongside Senate Bill 1981 delegates the lead authority for developing a state's climate action plan to another agency, not the Commission. Next slide, Ms. Hackenberry. In a separate proposed rule, the OTC also argues that the Commission may not approve any new permits for any new oil and gas operations until all the required rules have been adopted. I read that to include the baseline assessment since it's integral to the rest of the rules. And that would imply a moratorium of some indeterminate but very likely lengthy duration. The legislative history, as we've laid out, makes clear the legislation does not authorize a moratorium. Next slide, Ms. Hackenberry. Finally, the petition would also require the Commission to establish a climate adaptation and mitigation program. As I've already said, that may be within the purview of CDPHE, perhaps not. It would require the Commission to assess a fee equal to the social cost of carbon.
You're out of time, so
I'm done.
Okay.
I'll close by saying I don't believe the Commission has the statutory authority to do any of those things as well. With that, I'm happy to take questions.
Very good. Commissioners, are there questions for Mr. Martin? And if Ms. Hackenberger could get that slideshow to Ms. Larson, we would appreciate that.
We'll do so, Mr. Chairman. Thank you.
Thank you. Seeing no questions, we will allow you to be unimpaneled and bring on the next panel, Ms. Larson.
So next up, Mr. Chair, are the citizens groups, and Mr. Freeman will be presenting on their behalf.
Yes, Ms. Larson, I apologize. Mr. Delahanty will be presenting for us today.
Thank you. We will get him in one moment.
There we go. We can see you, Mr. Delahanty. Are you ready to present?
Yes, thank you.
Are you sharing a screen or just talking?
I will not be sharing a screen, just talking.
All right.
Thank you, Mr. Chairman. Thank you, Ms. Larson, and thank you to all of the commissioners for the opportunity to weigh in on this important issue. My name is Tom Delahanty. I'm appearing on behalf of the citizen groups. As the Our Children's Trust petition makes clear, climate change is happening right now, and it's having a very real effect on Colorado's people, environment, and wildlife. Oil and gas development in Colorado contributes to the problem. Because these impacts are directly relevant to SB 181's core goals, we support the petition and urge the Commission to adopt rules addressing climate impacts from Colorado's oil and gas operations. In particular, we support the proposed rule outlined on pages 44 to 46 of the petition, which would require, among other things, that the Commission establish statewide greenhouse gas emissions reduction targets for oil and gas operations. The rule would also impose various reporting and monitoring requirements to ensure those targets are met. This proposal aligns with and strengthens several components of the draft mission change rules. For example, the CITER database and other cumulative impact requirements can be leveraged to help address climate concerns. Similarly, the 900 series flaring requirements bear directly on climate change impacts. The Commission and staff should draw from the petition as they hone a cumulative impacts framework and other mission change rules. Critically, and contrary to what some parties have argued, this Commission does have authority to consider climate impacts as part of its permitting process. Neither the AQCC's general authority to regulate air emissions nor its specific mandate to address climate change under HB 1261 vitiates this agency's independent duty to address oil and gas operations' climate-related impacts to health, safety, welfare, the environment, and wildlife. To the contrary, multiple agencies regularly seek to achieve parallel goals. Certainly, the Commission should coordinate its efforts to minimize climate impacts with the AQCC's rules promulgated under HB 1261, and COGCC should also conduct holistic emissions information gathering to better inform its own permitting decisions. Robust greenhouse gas assessment, reporting, and monitoring, as laid out in this petition, are necessary for COGCC to fulfill its mandate under SB 181. Thank you all for your time and continued hard work.
Thank you for that presentation. Do we have questions? All right, seeing none, we will unpanel you and move to the next panel. Ms. Larson.
Thank you, Mr. Chair. That will be the Citizens for a Healthy Community. And give me a moment and I will get those members in.
Can you hear me?
We can hear you and we can see you. Yes, hello.
Wonderful, wonderful. Good afternoon, commissioners. My name is Natasha Leger. I'm the Executive Director for Citizens for a Healthy Community. I'm actually going to speak freely today. First of all, I want to echo everything that Mr. Bellinger said. The climate crisis really is the crisis of our time. It's an issue that should be front and center for this commission. This summer, it has been 110 degrees for 8 weeks consecutively in our garden with a high of 118 degrees. Delta County and the Western Slope has been found to be a climate hotspot with temperatures increasing 2.1 degrees Celsius at a faster rate than global averages. So what I would like to ask of you is that you consider the evidence that was presented in the Our Children's Trust petition seriously and look at it rigorously, just like you did the public health information. I welcome the opportunity to make a comment today, but I really feel more value would be in hearing from you commissioners in responding to that information and in really giving these kids, these youth that have brought this issue in front of you, the sense that you're listening to them and hearing them and trying to address that problem. As the lead regulatory agency around oil and gas, you have an obligation to regulate to address the climate crisis. Oil and gas represents 6% of contributing emissions, greenhouse gas emissions. With HB 191261 and the mandatory greenhouse gas emissions reduction targets, the COGCC really has an obligation to regulate in a manner that will help reduce, meet those reduction targets. So I just want to close by saying that I ask you to have that rigorous discussion around the evidence that has presented, because we have not heard that to date. And to
wrap up your pastime.
Sorry about that. Thank you.
Thank you. Do commissioners have questions? Okay, seeing none at this time, thank you for your presentation and for your involvement on the OCT petition. We will now turn to the next panelist. Looks like it's Ms. Merlin. Good to see you again, Ms. Merlin.
Thank you. Just before you start my time, for the record, I am married. So I usually go by Ms. Merlin.
Oh, sorry.
I wanted to have my 4-month-old daughter here, but she wasn't cooperating, so I had to hand her off. I don't see, let's see, I'm going to share my screen for my presentation. Okay, there we go. I wanted to bring my daughter in part because everyone else has been showing off their beautiful children, but also to show that this issue personally affects me, and I think many other people here today. So as you know, Martinez versus COGCC was a case that I was involved in response to a 2013 Our Children's Trust Youth petition. And in that case, this commission denied that permit on the grounds that it lacked authority to deny permits on the basis of health impacts, including climate change. SB 19181 changed all of that. Since 2013, we've lost a lot of valuable time in addressing climate change. So here's just some of the health impacts of climate change from the CDC. This is a health and safety issue, and thus its involvement in this rulemaking is appropriate. Some data on expected impacts in Colorado. I won't read all of these. I will show you this nice picture from the University of Colorado about what a warmer and drier Colorado will look like. I don't want my children to only know the Colorado on the right here. I want my children to know the Colorado that I have known on the left, which is majestic. Here's some articles from mostly 2020, but one is from 2019, on the effects of climate change that we're already seeing. My statement to you here today is that this commission actually lacks the legal authority to ignore the threat posed by climate change to health, safety, welfare, and wildlife. This commission's statutory mandate is not relieved by another agency's authority, especially where that agency lacks powers this commission has. These are the requests of the petition, 3 rules. These rules are, considering the magnitude of the threat, they are moderate and necessary to protect health, safety, welfare, and the environment. Colorado really can't meet climate reduction goals without regulating the production side of emissions. So I hope you'll look at the evidence in the Our Children's Trust petition. I hope you will take steps to evaluate and address climate change as part of your health and safety rulemaking. Thank you.
Thank you. Do we have questions for this witness? All right, seeing none, thank you for your presentation. We will move to the next panel.
Mr. Chair, that will be Ms. Ryan presenting on behalf of the Colorado Oil and Gas Association. And just for the record, Small Operators Society and Extraction Oil and Gas have asked that their time be allocated to the Colorado Oil and Gas Association. So Ms. Ryan will be, she has 6 minutes to present today.
Right.
Very good.
Excuse me. Good afternoon, commissioners. My name is Julia Ryan. I'm with Brownstein Hyatt Farber Schreck on behalf of the Colorado Oil and Gas Association, Extraction Oil and Gas, and the Small Operators Society. In deciding whether to grant the petition and its proposed rules, the Commission should look to the Colorado Supreme Court's unanimous 2019 decision in COGCC versus Martinez, which upheld the Commission's denial of a nearly identical petition, a petition that, just like the one before you, asked the Commission to condition permit approval upon a finding of no adverse impact to public health, the environment, and wildlife. As you'll hear, SB 181 did not overturn the Martinez reasoning as relevant here. The Colorado Supreme Court in Martinez unanimously upheld the Commission's denial on the ground that 1, the petition's no impact standard was inconsistent with the Oil and Gas Conservation Act, and 2, that granting the petition was unnecessary in light of rulemakings being conducted by the Commission and CDPHE. The current petition's no impact standard should be rejected on similar grounds. First, while SB 181 unquestionably altered portions of the Act, SB 181 did not delete the Act's goals of protecting against waste, safeguarding correlative rights, and maximizing efficient rates of production, subject to the other stated goals of the Act. The Martinez Court found the multiple goals of the Act dispositive as indicating, quote, a legislative intent to promote multiple policy objectives, end quote. The Martinez Court went on to hold that the multiple goals of the Act did not allow the Commission to condition new permits on a finding of no adverse impacts. You'll find protecting correlative rights and waste remain in the Act as amended by SB 181. Additionally and significantly, by including a requirement for, quote, minimizing and mitigating the extent and severity of those impacts that cannot be avoided, end quote, SB 181 leaves intact the court's conclusion that the Act, quote, envisions some possible environmental and public health risks, end quote. The Martinez Court explained that had the legislature intended to preclude any cumulative impacts, the statute would not have included the language and mitigate significant impacts. The same logic applies here. The Act's recognition of unavoidable impacts cannot be squared with the petition's mandate against any adverse impact. The General Assembly acknowledged in 181 that oil and gas development, like all human activity, carries some degree of unavoidable impact. Moreover, SB 181 requires the Commission to regulate oil and gas operations in a reasonable manner. There is nothing reasonable about the petition's no impact standard. No industry could meet this unreasonable standard. And while the language of SB 181 is itself enough to reject the petition, the legislative history of the bill is convincing as well. Most notably, when Representative Becker introduced the legislation, she stated that if local governments and the Commission, quote, have concerns about any oil and gas permit, they must first try to minimize adverse impacts. She then said, so this is not a zero impact bill, end quote. Additionally, because a zero impact standard is virtually impossible to meet, the zero impact standard becomes a de facto ban, a result SB 181 sponsors repeatedly invade against. In fact, the petition is a ban in two ways. First, it calls for the suspension of all new permits until its proposed rules are promulgated, which is a temporary ban or moratorium. And then the no impact standard I've been talking about is a de facto ban. But Representative Becker herself said 181, quote, is not a de facto ban at the state or local level, end quote. Senator Finberg said, quote, what this bill does not allow is a de facto ban, end quote. And in another instance, Senator Finberg said that 181 does not give the state or a local government, quote, blanket authority to do things like a ban or a long-term moratorium that is effectively a ban. Finally, as I mentioned earlier, the Martinez Court also held that the Commission appropriately exercised its discretion in rejecting the petition because the Commission was already working with CDPHE to address the Martinez petitioner's concerns. The Martinez Court noted that the Commission's finding that the issues implicated by the Martinez petition were being addressed in rulemakings elsewhere was, quote, precisely the kind of agency action to which courts owe deference, end quote. Here too, as you all have heard and know, the Commission is coordinating with CDPHE to reduce emissions and cumulative impacts and has proposed its own emissions rules for this purpose. Specifically, the Commission is coordinating with CDPHE to reduce emissions of VOCs, methane, and other pollutants in the 900 series rules. In addition, CDPHE has in recent years promulgated its very own aggressive air emission regulations, and has its own pending rulemakings, which will address many of the petition's concerns and even further reduce emissions. As the Martinez Court noted, there is no need for the Commission to take up a petition for rulemaking when it is already effectively addressing issues implicated by the petitioner's proposed rules. So, given the Act's multiple policy goals, undisturbed by 181, the fact that 181 acknowledges unavoidable impacts, and the fact that the Commission and CDPHE are already addressing the petition's concerns in this and other rulemakings, industry respectfully requests you deny the petition in its entirety. Thank you.
Thank you, Ms. Ryan. Questions? Thank you. We will have you zoomed away and bring our next panel on board.
Mr. Chairman, Mr. Neslin will be presenting on behalf of Noble Energy, Occidental Petroleum Company, and PDC Energy.
And does he have 6 minutes?
He does. Thank you. Yes.
Thank you, Commissioners. I'll try to take less than that. Dave Neslin, speaking on behalf of Noble, Occidental, and PDC. OCT's petition and proposed rules are flawed from both a legal and a policy standpoint. Now, you've heard much of the legal arguments, so I'll touch only briefly on those and focus primarily on the policy drawbacks. First, OCT's petition is not legally supportable. Their proposed rules would require that the COGCC prepare a climate recovery plan that sets greenhouse gas emission reduction targets for oil and gas. The Oil and Gas Conservation Act does not authorize the COGCC to undertake this work. Instead, the Air Quality Control Commission is the agency with authority over emissions control and air quality, and it is in the process of adopting rules to minimize emissions from oil and gas exploration and production. As the current mission change rulemaking has shown, the COGCC has been expending substantial time, effort, and resources implementing regulatory changes that SB 181 specifically requires. It should not accept OCT's invitation to add to the Commission's already full plate to adopt rules outside of its statutory authority and within the AQCC's authority. Second, OCT's petition ignores the many policy reasons to continue oil and gas development in Colorado. The petition assumes that oil and gas production is always negative and environmentally irresponsible, which is simply untrue. Colorado has some of the most protective oil and gas regulations in the nation, even the world. And the mission change rulemaking, along with other recent rulemakings concerning wellbore integrity, flow lines, school setbacks, air emissions, and ozone, make the regulations even more protective. Domestic oil and gas production also provides numerous social benefits. From an environmental standpoint, studies have demonstrated that the increased use of natural gas over coal to supply electricity has led to significant reductions in carbon dioxide emissions, which has led to air quality benefits. There have not been corresponding increases in methane emissions, according to studies. Studies have found little evidence for increases in total US methane emissions over the last decade, even though natural gas production increased by 46%. Specific to Colorado, oil and gas development has not led to significant increases in ozone. For their part, PDC, Noble, and Occidental have undertaken significant efforts to plug and abandon older wells with each new modern well they drill. For example, on average over the last 3 years, PDC has plugged and abandoned 3 older wells for each new well it drilled. Occidental has plugged and abandoned over 2,200 wells over the last 3 years. In 2019 alone, Noble plugged 850 wells, and as Chad Calvert testified 2 weeks ago, Noble has committed to plug approximately 2,300 more wells as part of its CDP. Because of technological advances, older wells are responsible for most emissions. Continued horizontal development has allowed companies to remove these historical sources of emissions. For example, the average greenhouse gas emissions reduction from each of Noble's plugged vertical production facilities is approximately 170 metric tons of CO2 per year. Approximately 770,000 metric tons of CO2 per year will also be removed from the elimination of truck traffic that was needed to service the older vertical wells. Oil and gas development has also led to economic benefits for the state and the public, adding $13.5 billion annually to state domestic product. Studies have found that nationally, oil and gas development has led to gains in total income, employment, housing. Domestic development, including development in Colorado, has also led to greater energy security in the United States. We are no longer dependent on securing the energy we need from hostile or precarious regimes overseas, as we had been for much of the last 3 decades. Finally, OCT's petition ignores a key distinction that preventing oil and gas extraction in Colorado will have little to no impact on oil and gas consumption by Colorado citizens or the emissions associated with such consumption. In 2018, approximately 70% of the energy we consumed came from oil and gas. Natural gas heats 7 out of 10 Colorado homes, provides about 20% of the electricity we use. Coloradans drive more than 5 million cars and trucks. We will continue to consume oil and gas for the foreseeable future. OCT's proposal would lead to the demise of the oil and gas industry in Colorado, but would have little or no impact on consumption. This outcome has been borne out in states that have banned hydraulic fracturing, including New York and Maryland, where the vast majority of energy consumed is still derived from oil and gas. It's just imported from other locations, other states, other countries. Similar to these states, an effective ban on oil and gas production, which is what OCT's petition would impose, would lead to importation of more oil and gas produced in places with less protective regulations than Colorado. Therefore, OCT's proposed rules will not decarbonize Colorado and may have the opposite result by leading to more importation of fossil fuels. The mission of this commission is not to end oil and gas development in Colorado or to displace it to other states. It's to ensure that the oil and gas that Coloradans consume is produced in a manner that's safe and environmentally protective. That is the objective of this commission. We know that is also my client's objective and that of the oil and gas industry. Thank you. I'd be happy to answer any questions.
Thank you, Mr. Neslin. We appreciate your closing on that. Do commissioners have questions? Okay, seeing none, we will move to the next panel. Ms. Larson.
Yes, Mr. Chair. So next up is Weld, Air, and Water, and they are represented by Ms. Matsumoto.
Good afternoon, commissioners and staff. Thank you once again for all of the work that has gone into this effort. I'm here briefly just to express the support of Weld, Air, and Water, Wall of Women, and Lowell and Margie Lewis on their behalf in support of the youth petitioners. I know you all read the petition. It certainly was a tour de force. It was nearly 60 pages with 120 exhibits, many of which are scientific studies and other reports of qualitative and quantitative data. Certainly time is at a premium for you all, and I encourage you to go back and reread those studies. But if your time is limited such that you're only able to reread one section again closely, I urge you to review the names and statements of the 65 youth petitioners. Like the clients I represent, these are real people who are simply concerned about their futures and the futures of their families and friends. They're concerned about a crisis we can all see isn't some distant future concern, but given the fact that our state and many states across the West are burning as we speak, the crisis is here today. Many of these young people are not old enough to vote and may not have much or any of their own income to use when exercising purchasing power to vote with their wallets, so to speak. So that's why it's critical for adults, especially those of us who are in positions to write or to influence laws and regulations, to really think long-term about the choices we make today and how future generations will be impacted. We support the reasonable requests of the youth petitioners, including the request to establish statewide greenhouse gas targets. And further, we encourage you to provide a response to the factual evidence and reasonable requests that those youth brought to you today. I'm happy to take any questions, and thank you again very much for your time.
Thank you for your presentation. Are there any questions? Okay, seeing none, we'll move to the next presenter, Ms. Larson.
Yes, thank you, Mr. Chair. The next scheduled presenter are the Western and Rural Governments Coalition. And I know there's a bit of a technical glitch, so I'm just waiting a moment before I'm able to bring in the presenter. So if we could take a brief 2-minute pause,
Yep.
I think that would be great.
Sorry about that. I took you up on the 2 minutes to find him, but I see we found him. So
I apologize, a little quicker than 2 minutes, so.
Mr. Jacobs, the floor is yours.
Chairman Robbins, Commissioners, thank you. Good afternoon. John Jacobs for Western and Rural Local Government Coalition. As you know from our brief written response to the petition of our Children's Trust, WRLG opposes the petition on multiple grounds and joins in the arguments of several parties that have responded just prior to us this afternoon. With our brief time for argument and opposition, WRLG would like to emphasize just a few key points about the petition. First, we agree with any number of other parties that this commission and CDPHE are already pursuing a number of the concerns raised in the petition, including as directed by the General Assembly last year in several pieces of legislation passed into law. This is a valid basis for respectfully denying the petition, as our own Supreme Court observed and specifically held in COGCC versus Martinez. Second, the Commission's Enabling Act, the Oil and Gas Conservation Act, as amended by Senate Bill 19-181, does not allow the Commission to take draconian measures such as those requested in the petition to elevate one of the many policy goals in the Act above all others. Instead, the Act directs the Commission to regulate the development and production of oil and gas in a manner that protects public health, safety, welfare, and the environment. The General Assembly has expressly recognized that the Commission's duty to regulate oil and gas development is not mutually exclusive from its duty to protect public health, safety, welfare, and the environment. Importantly, one of the overarching objectives of this very mission change rulemaking is to figure out the most effective ways for this commission to simultaneously regulate and not ban oil and gas development and protect public health, safety, welfare, and the environment. Additionally, it is readily apparent to WRLG and its members, and hopefully to each of you commissioners, that the underlying purpose of this petition is to stop all oil and gas development in Colorado. In order to accomplish this, the petitioner's proposed rules would require the Commission to condition future permit approvals on the finding of no direct, indirect, or cumulative impacts on any aspect of public health, the environment, or wildlife. This is an impossible standard for any energy producing sector to meet, even renewable energy technologies, and belies the true intent of the petitioners to have this commission effectively impose a ban on oil and gas development. Finally, we wish to note that the petition, even if granted, would not decarbonize Colorado and could actually end up exacerbating climate change by creating a scenario where more of Colorado's energy is imported from other areas and produced under less environmentally protective conditions, while also losing the jobs, economic benefits, and prosperity of producing our own energy responsibly, even as our energy mix evolves and changes moving into the future. This is short-sighted at best, and we trust that you will conclude that the relief requested by the petitioner is not only beyond your authority as a commission, but even if granted, would not achieve the petitioner's asserted objectives. We thank you for your attention to these brief remarks in opposition to the petition and respectfully urge you to deny the petition in its entirety. And I would lastly note that this request to deny does not preclude a written response to the petition as requested by Mr. Bellinger. Thank you for your time, and I'd welcome any questions.
Thank you for your presentation. Are there any questions from commissioners? Okay, seeing none, thank you again. Appreciate your,
Mr. Chair.
With that, Ms. Larson, have we concluded the presenters on the OCT petition?
We have, yes.
Okay, with that, I might want to call upon AAG Davenport to, I don't know, provide sort of, okay, we've got all the pleadings in, we've now heard the closing and then the SIR rebuttal. I know we have next steps. I don't know what they are. I know we're not going to do them today, but can you sort of provide some perspective to commissioners as well as to our stakeholders?
Thank you, Mr. Chair. I'm happy to do that. Commissioners, as the chair said, we don't have to do this today, but consistent with the APA's requirement to consider the petition as part of this rulemaking at some point in the course of your deliberations, I do recommend that you have a discussion about the petition and the rules proposed in that petition and make a decision regarding the petition and those rules. In other words, whether or not to incorporate any part of those rules into staff's draft rules or to reject them. But as I said, it does not have to be today.
Okay. Thank you, Assistant Attorney General Davenport. We will take that advisement. And I believe that concludes the agenda items for today. I would like to turn to Director Murphy, if she's with us still, to talk kind of next steps, process, etc. Director Murphy.
Thank you, Chair. And thanks everybody for your attention today. Staff has been working hard to incorporate the revisions that the Commission has requested over the course of the last 6 weeks. I think that we would like time to continue to refine some of those requested changes with the benefit of additional input from stakeholders and kind of working through them methodically. We could be in a place to present tomorrow morning, but I think that the flexibility to present at 9:30 on Monday morning would be a preferable option for us. We've been moving quickly, and I think having time to breathe and digest and think would at least benefit this director. But this, of course, is at your direction. And with that, I would say if you're intrigued by the possibility of maybe adjourning today and coming back Monday morning, we could reconvene on Wednesday then to hear from parties. It would give parties a little bit of time to review staff's proposals as well. I know that we've all heard the changes that you've requested, but actually seeing what the words look on paper may be different, right? And so it is to use the words of Chairman Robbins, a supposal. Suppose we adjourn today and come back Monday morning at 9:30.
So the concept is adjourn today until Monday morning, and then that gives staff tomorrow, as well as and we've all been working on the weekends, to make sure that you're comfortable with the the input we've asked you to provide back, which is consistent with the direction we've given you. I think that's entirely appropriate. You guys have been killing it, and you also have been doing a lot of work. As I mentioned to our stakeholders the other day, this process by which this commission has been undertaking its obligations is different. And this concept of high-level feedback and then getting stuff back has added to staff's work product. So so then we would do that Monday morning and then reconvene on Wednesday morning for closing statements of all parties. That gives parties, 36 hours to digest staff's proposals. And then, so closing statements Wednesday morning, and then we would move into deliberations. I, for one, am in favor of that adjustment. Other commissioners with questions? Commissioner Gonzalez.
Thank you. Can I get some clarification on what Monday might look like?
Director Murphy.
Thank you for asking the question, Commissioner. I wanted to actually touch on that and neglected to. I think the idea is that staff would be in a position to walk through the different hearing direction PowerPoints that I've been putting together, and then point to what the specific changes to language staff made was. So we would be in a position to send out red lines of the rules Monday morning, walk the commissioners and whoever's choosing to listen to us through those changes in the context of, the commission direction and where we did, and then try to kind of zoom out to some of the bigger picture interrelationship questions that I think are outstanding. All of staff except for Mr. Dronlow would be available in real time to talk through those changes, to talk through any questions you have, and then we would continue to be available to the commission on Wednesday and Thursday as parties are presenting and questions are continuing to unfold. Does that help, Commissioner Gonzalez?
Other questions, thoughts, considerations, thumbs up or down, any of the above? All right, you got 5 thumbs up. Ms. Larson, if you could once again nimbly adjust the agenda to reflect this change. Director Murphy, at what time would you like to present on Monday?
My vote would be 9:30, just to give all of us who have other commitments, who like to exercise in the morning, who have other jobs, a little space before we jump into some pretty heavy topics.
Mr. Chair?
Yes, Commissioner Putnam.
Just wanted to flag a procedural question. The Air Quality Control Commission is meeting late next week, including on oil and gas issues. So I'm trying to figure out how this will overlap, since I need to be in both places, and I think many of the parties are going to be interested in that as well. So I just want to make sure we can stitch those two pieces together for our sake and the stakeholders' sake.
Thank you, Commissioner Putnam. We apologize for our myopic prism of the world at times. When is the commission meeting next week?
I'm pulling up the agenda right now just so I make sure I've got the right pieces. So the rulemaking regarding Regulation 7, which I think will be of greatest interest to everybody, starts or is scheduled to start at 10 o'clock on the 17th, and is scheduled currently to continue through to probably 4 o'clock on the 18th.
Okay, the 17th is next Thursday. So now we're being nimble on the fly. Ms. Murphy, if we did your presentation Monday morning at 9:30, we can, again, we're making this up as we go. We could do Tuesday at 1 to start, and that gives us Tuesday and Wednesday. And I'm, again, just throwing stuff up against the wall. I don't want to hold our hearings while they are holding their hearings. We have many parties that are in both, and at least one commissioner that's in both. And well, Putnam's good. He's not that good. So what do folks think about that? That would give basically a 24-hour turn from the time that you present to the time that parties present, and then we start deliberating. Director Murphy?
First, I want to apologize for the oversight. I've known about those hearing dates for months, and so I lost track of it this afternoon in my enthusiasm for refining rules and trying to get it right. I think staff can put out drafts of most of the rules over the course of the weekend, so people have a little bit of time to digest them if they don't have the gloss or the perspective that staff would provide during a presentation. And so I think that could be workable. I hesitate to speak for all of the parties on that.
I think that makes sense. I think that I know that you've indicated to me that you are closer on some series than you are on others, and one may even be done. So why don't we just, again, be nimble, and as things get available, have Ms. Larson send them out to commissioners and send them out to all of our stakeholder parties. Hey folks, monitor your emails, and that way they can review them. And then when they hear your presentation at 9:30 on Monday morning, they will hear your presentation in concert with what they've already read for some of it. And then some of it may be new because you may be pushing out specific red lines on Monday as part of your presentation. Commissioner Messner.
Thank you, Mr. Chair. Understanding that, I guess as I'm looking at my calendar, does it make more sense rather than trying to kind of slam everything in together before the beginning of the AQCC hearings to do staff presentation on Monday, and then start with party presentations and deliberations on a Monday the 21st, and just give everyone a week there? And I'm thinking aloud here, right? So I'm just throwing stuff out. Is that because I don't think there's anything else happening that week, but well, I apparently have a meeting with you, Julie, but
I don't know if I can reschedule it.
Well, Commissioner, I'll take your bet now. Add to it. I like that idea. I think right is better than rushed. And since we've pushed 8, 9, and 12 out, we do have more time available to us. And so what I would suggest is let's give staff until, say, Wednesday morning for their presentation, and then start on Monday the 21st for deliberation. There's no reason for staff to have to hastily work all weekend to meet an arbitrary deadline on Monday. And that way we're starting up deliberations with a solid 5 days ahead of us. I don't think it's going to take that long. And we're not trying to hurry to meet our sister agencies' important rulemaking. Director Murphy, does that work for you and staff? Commissioner Putnam.
Thank you, Mr. Chair, and thank you for coordinating your schedules around our commissioner. Really do appreciate that, and I know a number of the stakeholders will appreciate that as well. One suggestion going in that way, knowing that there's a gap and that we've had questions come up about submission of written materials kind of in the middle of this, either individually or to the commission as a whole, is just suggesting maybe another reminder either from you, Mr. Chair, or from the Attorney General's, just on whether or not we should be considering, or people should be sending that, and then suggestion maybe to send out a written reminder of that to, assuming that we're in a place where people shouldn't be sending substantive response by emails, and we'll be disregarding those. I think it's important for people to know that, so that everybody goes in with the right expectation.
AG Davenport, would you like to send the polite reminder?
I'm happy to send the polite reminder. And would you like that now, Mr. Chair, and then also in writing later?
Yeah, why don't you do it now orally and then do something in writing to the stakeholders via Ms. Larson's list?
Happy to. In regards to the 2 through 600, parties have already had an opportunity to submit their written pleadings, position statements pursuant to the case management order. And so in agreement with my prior statements, parties are still not allowed to send substantive written pleadings to the entire commission regarding the 2 through 600 series. Parties may communicate with individual commissioners in the interim, but as we previously discussed, what we're asking is that the parties email that individual commissioner with a request to meet and a brief description of the topic, but not include substantive communication, substantive comments or argument or documents. It remains up to the individual commissioner whether or not to respond or hold that conversation, and that commissioner has no legal obligation to respond or have that conversation. In regard to the 8, 9, and 12, we do have a schedule for parties to submit written pleadings, and they should stick to that schedule in the case management order. And I'm happy to have Ms. Larson or anybody else chime in if I've misstated, especially the 8, 9, and 12 case management schedule.
Anything to add, Hearings Officer Larson or AAG Minor? And you don't have to. Nothing. Okay.
No, I don't.
Okay. Okay, so let me summarize where I think we are, just to make sure that we're crystal clear. I think where we are is that we would adjourn this afternoon and that we would reconvene on Wednesday, September 16th at 9:30 a.m. for the staff report. And then we would convene on Monday, the 21st at 9 a.m. for party closing statements, followed into deliberations. I'm seeing lots of heads nodding up and down, and that's generally consent. So I think that's what we'll do. Can I have a motion along those lines?
Mr. Chair, I will make a motion to adjourn until 9:30 a.m. on Wednesday, September 16th.
Do we have a second? Second. Great. All those in favor indicate by saying aye. Aye. Any opposed? No? We're adjourned.
Thanks, everybody.
Thank you.